Do you think jurors really don't talk about the trial during the course of breaks? You want to know what this is all about and why it's important for you to understand? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury lawyer practicing law in the state of New York. Now, at the beginning of every civil lawsuit here in New York, the judge will tell the jury as part of his preliminary instructions that under no circumstance are the jurors to talk about this case, the details of the case, at any time except for after the trial is over and now they go back and start to deliberate. That's the only time they're supposed to talk about the facts and the details of the case. But some people say, I don't believe that. I think when the jurors are out on breaks and they're chit-chatting, I think they really do talk about the details of the case. Well, let me share something with you that I think will open your eyes. During the course of jury selection, when the attorneys are picking a jury to see who is going to be sitting and deciding your case, one of the things we ask the jurors is whether they can follow the legal instructions that the judge gives them. And if they find that somebody is not following the judge's instructions, would they have any hesitation whatsoever in notifying the court and telling the judge that one or more of the other jurors are not following their instructions? And each and every one of these jurors promise and they commit to notifying the court if one of the jurors or more are not following the judge's instructions. So, although you may think that when the jurors go back during a break and now are waiting for the trial to resume, you might think, hey, the only other thing they're talking about is your case. The reality is they are not supposed to talk about the case. You want to know why? It's because they don't have all the evidence. It's because they haven't heard all the testimony. It's because they're missing key pieces of information. And the only time they'll get all of that is by the very end of the case, and after the attorneys give closing remarks, and after the judge gives them instructions on the law. And then he tells them, go back and start deliberating. Then and only then are they permitted to really go into and delve into the details of the case to determine whether we are more likely right than wrong that what we are claiming is true. So why do I share this quick information with you? I share with you just to give you an insight and an understanding into what goes on in these civil lawsuits involving accident cases and medical malpractice cases and even wrongful death cases here in New York. You know, I recognize that you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need to be answered first, what I encourage you to do is pick up the phone and call me. You know, I answer questions just like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.